Thank you, Mr. Chairman, and Ranking Member Meng for holding this important hearing, and thank you, Attorney General Bondi, for appearing before us today. Madam Attorney General, I serve, in addition to the Appropriations Committee, as a ranking member of the Committee on House Administration. I sent you a letter last week, along with my Republican counterpart, Chairman Brian Stile, requesting an increase in federal prosecutory resources to address threats against members of Congress, particularly in light of what happened last week in Minnesota, that tragedy. In 2024, the U.S. Capitol Police identified and received nearly 9,500 concerning statements or threats against members. Federal prosecutors have only secured 8 convictions so far, and the heightened threat environment demands an all-hands-on-deck approach. Will you commit to assigning an assistant U.S. attorney or a special assistant U.S. attorney in each of the 94 federal districts to, at least on a part-time basis, investigate and prosecute threats against members of Congress?
What makes this situation even more disturbing is not just the number of threats, but the staggering gap between threats made and justice served. Out of nearly 9,500 reports, federal prosecutors secured only 8 convictions. 8? That means that in the vast majority of cases, those issuing threats never faced meaningful consequences. To the average citizen, that kind of statistic sends a dangerous message that threats against democracy's representatives can be made with little fear of real punishment. For lawmakers, it creates a climate of fear and vulnerability. For the public, it undermines faith in the justice system's ability to protect those who are supposed to protect them. This mismatch between volume and accountability exposes a serious strain on federal prosecutorial resources. Threat cases are complex. They require careful investigation to determine credibility, intent, and the likelihood of violence. But when the system only produces 8 convictions, it shows either a lack of resources, a lack of prioritization, or both.
So thank you for bringing that up, and I take that very seriously. Not only what happened in Minnesota was horrible. I've spoken to Keith Ellison. I've spoken to Amy Klobuchar about that. It's horrible. We are involved in that. The FBI was involved. Our U.S. attorneys are involved. Many of these are district to district. So the way we're doing that is, I will tell you, my National Security Division is involved in all of those and assisting in those. We meet every single morning and we discuss that. But many of those, Minnesota, will be handled in the state in which it happened. Another one is Governor, I'm sorry if I can keep going. I'm sorry. I don't mean
Quickly,
to.
though.
I filibuster. Governor Shapiro and what happened in Pennsylvania with Governor Shapiro. I've spoken to Governor Shapiro. We are working hand in hand, our U.S. attorney with the district attorney there, hand in hand, just like in Minnesota. I made sure our U.S. attorney and our district attorneys there were working hand in hand. Political party doesn't matter when something like this happens. And I also want to make sure all members of Congress are safe as well.
Okay, and I would...
The idea is simple, but its impact could be profound. Right now, many cases slip through the cracks because they are scattered across jurisdictions, handled inconsistently, or simply not prioritized amid the mountain of other crimes federal attorneys must handle. By dedicating even part-time prosecutors specifically to these cases, it signals that threats against lawmakers are not just another case file. They are attacks on democracy itself. Each district attorney would become a frontline defender, ensuring that every credible threat is taken seriously, investigated, and prosecuted when necessary. This could finally begin to close the dangerous gap between the thousands of threats reported and the tiny handful of convictions secured. It also sends a strong message to those who believe they can intimidate elected officials without consequence. The knowledge that every district has a prosecutor watching for these crimes raises the stakes for would-be offenders.
Okay, and I would reiterate, Chairman Stile and I think Chairman Stile and I agree that at least a part-time in each of the 94 districts would be appropriate. Let me change topics for just a moment.
I'm really quick on that. Yes, we're doing that through our National Security Division, so I think that's already in the works, and I would be glad to meet with you in a secure facility to talk about that.
Very good. Thank you. Continuing, in addition to my role here, the committee that I serve on as an authorizer oversees Capitol security as well as federal elections, so I'm closely following the aftermath of January 6th. Recently, several defendants who received presidential pardons related to that day are now arguing in court that the pardon covers crimes like, for instance, illegal firearm possession discovered in a search of an individual's home in California months after January 6th. What's your position on whether the pardons cover these separate offenses?
That idea is deeply unsettling because it undermines the entire principle of equal justice. A pardon is supposed to address a specific crime or conviction, not become a lifetime license to avoid responsibility. If courts begin to accept the notion that a single act of forgiveness can stretch endlessly to cover unrelated offenses, it would set a precedent that no one is truly above the law, except those lucky enough to have been pardoned. And once that door is opened, it could be exploited again and again, weakening the very structure of accountability that the justice system relies on. The tension in the congressional hearing over this issue was palpable because the representative pressing the question wasn't just concerned about the technicalities of January 6th cases. He was worried about the bigger picture. He demanded to know whether the Department of Justice, sworn to uphold the Constitution, would take a clear stance on the limits of pardons. But instead of answers, what came back was hesitation, deflection, and references to pending litigation. The Attorney General avoided committing to a firm position, and that silence was as loud as any statement could have been. It suggested uncertainty, or worse, unwillingness to confront a question that could reshape the power balance between the executive branch and the rule of law.
The pardon power rests with the president, not the Department of Justice, and some of that is pending litigation, and I cannot discuss pending litigation.
Well, I'm not asking you about who has the right to a pardon. I think as the Department of Justice in February wrote, the pardon is an act of grace which removes the punishment from a crime a person has committed. It further said, in its effect, the granting of a pardon is in no sense the overturning of a judgment of conviction. It is an executive action that mitigates or sets aside punishment. So as the chief law enforcement officer, what's your opinion, not the president's power of whether he can offer a pardon? That's pretty clear in the Constitution. But for crimes committed unrelated to January 6th, would you suggest that the pardons would cover activities or crimes potentially committed outside of that by the same person?
Well, I don't know if you're referring to Joe Biden pardoning his son after he said he would not pardon Hunter Biden, or the
No, I actually
commutation
referred
of
to
all
January
the
6th. I'm sorry.
all the sentences that the people that were on death row. I've met with those families.
No,
and
I-
all of those sentences were commuted. I'm not going to comment on pardons on either side of the aisle.
So, well, I'm not asking about either side. I'm asking, you're the chief law enforcement officer in the United States. You have a responsibility directly, but you swore an oath to the Constitution, not the president. Want to know what your views are on the extent to which pardons cover potential crimes committed by individuals who've been pardoned but unrelated to January 6th.
Do you mean the ones that were done by the auto pen? I'm not going to discuss
right.
anything that
Mr.
could
Chairman,
be or not be
I
pending litigation.
respectfully, Ms. DeLauro accused you of filibustering. I think that's the height of filibustering. This is a serious, serious topic. And for you to suggest that you don't have an opinion or to divert to other things that had nothing to do with January 6 pardons, I think is frankly demeaning to your responsibilities and your job. With that, I'll yield back.